Understanding JCAM Articles 26, 27, 28, 29, and 30. Welcome back. Today, we are taking an exhaustive, highly detailed look at the Joint Contract Administration Manual, or JCAM, covering Articles 26, 27, 28, 29, and 30. In this segment, we are going deep into uniform allowances, employee claims for lost or damaged personal property, employer claims and financial demand letters, driver's license requirements, and local memorandum of understanding negotiations. Let's break down each one step by step with complete technical precision. Part 1, Article 26, Uniforms and Work Clothes. We begin with Article 26, which governs uniform eligibility, annual financial allowance allocations, voucher administrative rules, safety footwear standards, and joint uniform committees. Article 26 mandates that the Postal Service provide an annual uniform allowance to all eligible letter carriers who are required to wear a uniform while performing public-facing delivery duties. This includes full-time regular carriers, part-time flexible carriers, and city carrier assistants who reach 90 calendar days of employment or 30 working days, whichever comes first. The annual uniform allowance is not a cash payment, it is a dedicated credit allotment administered through a uniform vendor procurement card system or formal voucher process. Under Article 26, new eligible career and non-career carriers receive an additional initial entitlement bonus on top of their annual base allowance to cover the heavy cost of acquiring essential baseline gear, such as outer parkas, rain gear, footwear, trousers, and shirts. Under Section 2 of Article 26, uniform items must strictly comply with Joint Postal Union quality standards. Furthermore, management is required to allow carriers to wear authorized seasonal uniform items, such as shorts, sun hats, or cold weather gear, in accordance with climate conditions, and local management cannot arbitrarily enforce uniform rules that contradict national guidelines or approved uniform combinations outlined in Section 930 of the Employee and Labor Relations Manual. Let's examine two distinct real-world examples to understand how Article 26 is applied on the workroom floor. Example 1, Allowance Denial and Delay. A newly hired city carrier assistant completes their 90 calendar day probationary period. Management fails to process the required administrative paperwork to issue the CCA, or Initial Uniform Allowance Card. After 4 months on the job, the CCA is still carrying mail and personal street clothing, and the supervisor tells them, "We are waiting on district HR, so you just have to wait." Violation: management is contractually obligated under Article 26 to process and issue the uniform allowance immediately upon the completion of the eligibility threshold. Delaying allowance access forces employees to perform delivery duties without proper uniform identification and weather protection. Example 2, arbitrary uniform restrictions. During an intense summer heat wave, several letter carriers report to work wearing officially licensed postal walking shorts and authorized postal knee socks. The postmaster issues a station memo stating, "Shorts are prohibited at this facility starting today, all carriers must wear full-length trousers." Violation: local management cannot unilaterally alter or ban contractually approved uniform combinations. Because authorized walking shorts are a recognized uniform option under Article 26 and postal handbooks, the postmaster's blanket prohibition is an illegal rule change. Part 2, Article 27, Employee Claims. Next is Article 27, which provides a formal legal process for employees to seek financial reimbursement from the Postal Service when their personal property is lost, damaged, or stolen while on duty. Article 27 establishes that the Postal Service will compensate an employee for loss or damage to personal property reasonably used in connection with their employment, provided the loss was not caused by any negligence or fault of the employee. To qualify for reimbursement under Article 27, a claim must meet 5 essential criteria. Timely filing: the claim must be submitted on PS Form 2146 within 14 calendar days of the date the loss or damage occurred or when the employee first became aware of it. On-duty scope: the personal property must have been damaged, lost, or stolen while the carrier was performing official postal duties or while the property was located on postal premises. Reasonable necessity: the item must be something reasonably required or expected on duty, such as prescription eyeglasses, a wristwatch, a personal phone used in emergencies, or necessary footwear. Absence of employee negligence: the loss cannot be the result of the carrier's own careless behavior, such as leaving personal electronics unattended in an unlocked postal vehicle in a public area. Depreciation and cost proof: the claim must be accompanied by receipts, repair estimates, or proof of the item's purchase value to calculate fair market value. Let's review two operational examples showing how Article 27 claims function. Example 1. Eyeglass damage during mail delivery. A letter carrier is walking their park and loop route when a low-hanging tree branch breaks off in a high wind gust, striking the carrier in the face and crushing their prescription eyeglasses. The carrier submits a PS Form 2146 with a replacement prescription receipt within 8 days. Management denies the claim, stating, eyeglasses are personal items and USPS doesn't pay for personal property. Violation: prescription eyeglasses are necessary for duty. Because the damage occurred while performing official work and was not caused by carrier negligence, management's flat denial violates Article 27. The carrier is contractually entitled to fair reimbursement. Example 2. Theft due to unlocked vehicle. A carrier leaves an expensive personal laptop sitting exposed on the passenger seat of their LLV with the door wide open while delivering a 15-minute apartment relay. An unknown individual walks up and steals the laptop. The carrier files an Article 27 claim. Application: in this scenario, management's denial of the claim would likely be upheld because the carrier exhibited clear negligence by leaving an unlocked vehicle exposed with valuable personal property inside, directly violating security rules. Part 3, Article 28 Employer Claims. Moving to Article 28, this section governs employer financial claims against letter carriers, specifically when management attempts to collect money from an employee for alleged salary overpayments, short ages, or damaged postal property. Article 28 serves as a shield against improper financial demands. It mandates that management cannot simply demand money or make unauthorized payroll deductions whenever mail is lost, a vehicle is damaged, or a payroll error occurs. Key procedural mandates under Article 28 include: proof of negligence: management cannot collect money for loss or damage to postal property, equipment, or vehicles unless they can establish, through clear evidence, that the carrier was personally guilty of gross negligence or intentional misconduct. Written demand notice: management must issue a formal written letter of demand outlining the specific reason, calculation, and legal basis for the financial claim before attempting any payroll collection. Debt Collection Act procedures: under Article 28 and Section 480 of the Employee and Labor Relations Manual, if a carrier files a grievance challenging a letter of demand under Article 15, management is strictly prohibited from withholding funds or deducting money from the carrier's paycheck until the grievance process, including arbitration, has reached a final conclusion. Waiver of claims for overpayment: if the Postal Service accidentally overpays a carrier due to an administrative or accounting error through no fault of the employee, the carrier has the right to request a formal waiver of claim for erroneous payment under federal regulations. Let's examine two station scenarios involving Article 28 financial disputes. Example 1, Vehicle Damage Assessment. A carrier is backing an LLV inside a tight post office parking lot and accidentally clips a stationary loading dock bumper, causing $300 in dent damage to the rear fender panel. The postmaster hands the carrier a handwritten note stating, "You owe the Postal Service $300 for vehicle repair. We will deduct $50 from your next 6 paychecks." Violation: this violates Article 28 on multiple levels. Management cannot collect money for routine vehicle damage without proving gross negligence, failed to issue a proper formal letter of demand, and illegally threatened automatic payroll deductions without honoring the Grievance and Debt Collection Act process. Example 2. Grievance hold on salary overpayment demands. Management conducts an audit and realizes they accidentally overpaid a carrier 40 hours of overtime over 3 pay periods due to a time card entry mistake. Management issues a formal letter of demand for $1,200. The carrier files an Article 15 grievance challenging the math and requesting a waiver. Despite the active grievance, payroll immediately deducts $300 from the carrier's next check. Violation: deducting funds while an Article 28 demand is actively being challenged and the grievance procedure violates the mandatory stay of collection protections guaranteed under Article 28 and the Debt Collection Act. Part 4, Article 29 Limitation on revocation of driving privileges. Next, we examine Article 29, which regulates state driver's license requirements, government driving permits, and strict limitations on management's authority to suspend or revoke a carrier's driving privileges. Article 29 mandates that every letter carrier whose position requires driving must hold a valid state driver's license. If an employee's state driver's license is suspended or revoked, or if management temporarily suspends their internal driving privileges following a vehicle accident, Article 29 sets mandatory protections. Individual evaluation: management cannot automatically revoke a carrier's driving privileges across the board based on a single minor incident. Any decision to suspend or revoke driving privileges must be based on a fair, objective, individual evaluation of the carrier's driving record. Reassignment obligations: if a carrier's driving privileges are suspended or revoked, management is contractually obligated to make every reasonable effort to reassign the carrier to an available non-driving assignment, such as a foot route, indoor casing duties, or clerk work within the facility, to ensure the employee continues to work their regular hours. Immediate restoration: once the carrier's state driver's license is legally restored or the safety evaluation is cleared, management must immediately restore the employee's postal driving privileges without unnecessary administrative delay. Let's look at 2 practical examples demonstrating Article 29 in action. Example 1. Failure to seek non-driving accommodation. A regular letter carrier has their state driver's license suspended for 30 days due to an off-duty traffic citation. The carrier immediately notifies management. The postmaster tells the carrier, "You can't drive, so you are placed on emergency unpaid leave for 30 days, go home." In the same station, there are 2 full-time foot routes with 0 driving requirements that are currently vacant. Violation: management violated Article 29 by failing to make a reasonable effort to reassign the carrier to available non-driving work. Because non-driving routes were available, management was contractually required to accommodate the carrier rather than forcing them onto unpaid leave. Example 2. Automatic revocation without evaluation. A carrier with a 20-year clean driving record gets into a minor parking lot fender bender, causing a scratch on a light pole. The supervisor immediately issues a written notice revoking the carrier's postal driving privileges indefinitely, stating, "Policy says any accident means automatic loss of driving." Violation: Article 29 strictly prohibits automatic, blanket revocations. Management must conduct an objective, individual assessment. An automatic revocation without evaluating the carrier's overall safe record directly breaches Article 29. Part 5, Article 30 Local Implementation. Finally, we analyze Article 30, which establishes the formal framework for negotiating local Memorandums of Understanding, or LMOU, between local NALC branches and local postal management. Article 30 grants local parties the legal authority to negotiate specific local operational rules that supplement the national agreement. However, Article 30 strictly limits local negotiations to 22 specific contractual items. Key items among the 22 authorized bargaining subjects under Article 30 include: Item 4. Formulation of local choice vacation period schedules. Item 7. Determining whether employees may curve or split vacation selections. Item 8. Establishing local rules regarding jury duty and national convention leave. Item 9. Determining the maximum number of carriers who can be off on annual leave during choice vacation periods. Item 13. The method of assigning carrier technicians T6 to cover vacant routes within their group. Item 14. Establishing light-duty assignments within the installation. Item 20. Local rules governing overtime desired list rotations by section or facility. Under Article 30, local negotiations occur during a specific window following the ratification of the national agreement. An LMOU cannot conflict with or override any provision of the national agreement. If local management and the local NLC branch reach an impasse on any of the 22 items, the dispute is submitted to an expedited national impasse arbitration process. Once an LMOU is agreed upon or awarded, its provisions carry the full force of a contract. Let's review two distinct operational examples involving Article 30 LMOU enforcement. Example 1. Unilateral alteration of vacation quotas. The local LMOU explicitly states under Item 9 that 15% of the letter carrier workforce must be approved for annual leave during the summer choice vacation period. Facing a staffing shortage, the postmaster posts a memo announcing, due to low staffing, we are capping summer vacation at 5% this year. Violation: an LMOU is a contractually binding agreement under Article 30. Local management cannot unilaterally alter, reduce, or rewrite agreed upon LMOU percentages or rules without formal negotiation and agreement with the local union branch. Example 2. Overstepping authorized bargaining scope. During local LMOU negotiations, a local postmaster insists on inserting a clause stating that carriers must case 20 letters per minute instead of the national standard of 18 per minute. Violation: Article 30 limits local implementation strictly to the 22 designated items. Casing standards are governed nationally by handbooks and Article 19, therefore, management cannot force negotiations or insert clauses on non-authorized subjects outside the 22 items. Conclusion. In summary, Articles 26 through 30 establish critical individual rights and local operational structures. Article 26 guarantees proper uniform allowances and approved gear. Article 27 protects personal property through fair reimbursement claims. Article 28 shields carriers against arbitrary financial demands and protects paychecks during grievances. Article 29 limits driving revocations and mandates non-driving work accommodations. And Article 30 establishes the legal power of local memorandums of understanding across 22 specific bargaining items. Thank you for watching. As always, consult your local shop steward or the JCAM for specific grievance applications at your station. Stay safe, stay hydrated, and work at a pace you feel is safe.